Welcome to Media Reporter. Today we're talking with Samantha Pownall, who's an Equal Justice Works Fellow, an attorney at the New York Civil Liberties Union, and an adjunct professor at New York Law School, where she will run the Suspension Representation Clinic and Seminar. Samantha, welcome to Media Reporter.
Thank you for having me.
I don't think most people are cognizant of the fact that school discipline can or should be looked at through the lens of the criminal justice system. How did you develop a career where you're so focused on the legal rights of students?
After college, I was a teacher for several years, and I realized that there were a number of factors that impacted my students' lives outside of the classroom and that I had very little control over. As much as I wanted to keep teaching and as much as I then missed teaching, I decided to go to law school in order to try to figure out what I could do about some of these bigger picture challenges that my students were facing. Some of which deal with the disciplinary system. My students would disappear from my class for days at a time. And others, of course, dealt with students who had disabilities that the school was not meeting through various other resources. And so in law school, I took every opportunity I could to learn about how I might be able to protect the rights of students to access what in New York is their constitutional right to a public education. And if you are a student with a disability, you have the right under federal law to a free and appropriate public education. And so in my clinics, I represented students who were being denied services that they were required to be given through their schools through something that's called an individualized education plan, or an IEP. And then I also started to represent students who were being suspended from school. And that's really what sort of started me thinking about the issue of discipline and arrests as well in public schools, because police officers work in public schools. And that prompted a project proposal for my fellowship, which would allow me to try to change some of the local regulations and codes that impact young people's access to education in New York City.
And I have a confession to make. I was a bad kid, and I know that I had wonderful parents because I managed to survive my adolescence with nothing that I know of on my permanent record. And I guess what I was wondering is there the proverbial permanent record that kids are threatened with, and how does school discipline impact a child or a person's life going forward?
That's a really great question, and you touched on something that is so important for a young person to have, which is a strong advocate. And it sounds to me like your parents were able to be an advocate for you when you screwed up, like all kids screw up, all kids make mistakes. And so I think that sometimes there are challenges if a parent can't take time off from work to be there to represent their child or to help them tell their side of the story to the school. And oftentimes there are a lot of rules and regulations, especially in New York City, that parents are just unaware of because that information is not made readily available. And so it seems like there's a real due process issue there when you don't even have the information that you would need in order to raise a defense if you're being excluded from school. So, I'm sorry, what was the second part of your question?
No, just how does this impact a
right.
child's life? If I did have the black mark on my record, what would have been the effects of that going forward?
Okay, that's a great question. So in New York City, there are two different kinds of suspensions. There is a principal suspension, which is a suspension of 1 to 5 days, and then there is a superintendent suspension, which is 6 days and up to 180 days, which would amount to a full school year. And in the second type of suspension, the superintendent suspension, students are entitled to a hearing in front of an impartial hearing officer, which is a judge, basically, who determines, based on evidence the school presents and evidence the student presents, whether or not the suspension was warranted. The result of these long-term hearings can be either that the case is dismissed, in which case it is not in the student's file and not on their permanent record, which I'll talk about whether that exists or not in a moment. And the second option is that the requested number of days that the school is trying to suspend the student for may be reduced. And if you have a good advocate, like for example, a parent or an attorney or a law student representing your interests, chances are that there will be some kind of reduction in the number of days that the student will be suspended. And then finally, in the very rare occasion that a student brings imminent and real threat of physical injury into a building, either through a weapon or something like that, then it is likely that there will be no change in the suspension and the student will be suspended for that recommended time. Now, in the latter two situations where the suspension remains, this does stay in the student's file, and this is particularly important for high school students who are applying to colleges. The Common Application now asks whether a student has been suspended, and so they have to put forth that information. And if it's a principal suspension, that doesn't technically go on the permanent record. The principal suspensions are the shorter ones of 1 to 5 days. However, again, unless that is expunged from the record through some kind of appeal process or through a conversation with the principal, which in general principals are reluctant to have, then that will stay in the student's file. And again, if you are asked, have you ever been suspended in high school, you're required to admit that.
Oh, I guess there's two kind of follow-up questions to that. The first is, and I'm not, these might be areas of research that you haven't done, but if you have, great. If not, if you just have an anecdotal sort of understanding of this, does this really have a negative impact on admissions to college, which would seem obviously yes, but just if you have some data on that. And then the other thing is there any kind of a trajectory that people have seen from these kind of bad records to adult criminal activity or incarceration, things like that?
Absolutely. I mean, I feel like in your question, what I'm hearing almost is a description of a school to prison pipeline, right? So as soon as a child is suspended and removed from school, their chances of being involved in court or or sort of winding up before a judge or even spending a night in jail spike by a significant amount. And you talked about the impact on admissions to colleges. I mean, I think first and foremost, we have to look at the impact that suspensions have on students' access to learning. So if you're suspended from school for 180 days, 90 days, 60 days, 30 days, these are school days, not calendar days. So they could be out for months at a time. And that means then that their grades will fall and that they are not preparing for exams that are required if you're in middle school to get into high schools, particularly the specialized high schools of your choice. If you're in high school, you're not getting the instruction that you need in order to prepare for those standardized exams and just sort of get the credits that you need in order to graduate. So it's a significant setback. While the New York City Department of Education provides something called an alternate learning center, the quality of instruction that's provided at these centers varies significantly. So, for example, some centers, which perhaps are smaller, can actually have a beneficial effect on the student who is suspended and attending that center, because they can provide that student with perhaps more individualized attention, or the student feels like they're finally able to focus because they're not sort of in as large of a classroom. On the other hand, at the New York Civil Liberties Union, where I now work, we get a lot of calls from students where you've got students from different ages and different grade levels and different learning abilities, all in the same room, and one teacher who might be multiply certified but unable to then teach across this great swath of experience and abilities for students. So they really, depending on the center, students can miss out on a lot of information, which then of course impacts their preparedness for college. In terms of admissions and data like that, we don't actually have that. I don't actually have that data collected yet, but I think it's important to really think about how there is a right to an education in New York, and how this school, the government agency cannot take away that right without following certain due process rights, one of which is when you are removed from the traditional classroom setting, you are given some alternate instruction that will allow you to progress and not fall behind once you return to school.
So I guess one of the other side of this question is sort of how would you suggest that schools balance the needs of just having a calm and orderly classroom? Like if you had a teacher that was dealing with a discipline problem, how do they balance the needs of the student who's the discipline problem, which is what your focus is, with the needs of having their class environment not being disrupted?
Sure, that's an excellent question, and it goes straight to the heart of school climate and, to be quite frank, leadership in the Department of Education. So for several years, over the past 10 years since Mayor Bloomberg took over, and even before Mayor Bloomberg, and across the country, to be honest, there has been this approach to school discipline called zero tolerance, which proponents say would be a fair way, because for every infraction, right, you respond strictly and swiftly and extremely to all kids. What has happened, however, is that that subjective offenses, the way zero tolerance is applied to those offenses, actually varies greatly depending on the school, depending on the district, and of course depending on the student. So for example, a subjective offense is a student talking back. Let's say a teacher is trying to teach a lesson and the student just keeps making noise in the back row. Teacher keeps turning around, who's making that noise. And eventually the teacher sends the student to the principal's office, and then the student is suspended for defying the lawful authority of a teacher, or in what used to be called insubordination in New York City. So that's a subjective offense, and that's a zero tolerance response to immediately request something as extreme as an out-of-school suspension for that kind of behavior. An objective offense would be something like, I have,
contraband in class.
Sure. Contraband in class, or something that you can see. I'm smoking outside. That's an objective offense. If you look at the data, Black students are far more represented in the subjective offense categories than white students are per their population in New York City schools. And when you have something like zero tolerance, you have teachers and principals saying, oh, I have to respond aggressively to every response to project this image that we have it under control, that we're not going to tolerate even the smallest mistakes. But what you're missing there is a real opportunity to ask why the child is acting out. And so in terms of answering your question about finding that balance, I mean, there are a few suggestions. One is that I think that the DOE needs to help, as it has over the past 10 years, required teachers to respond, and principals and administrators, who are the ones empowered to dole out the principal suspensions. A teacher can ask for it, but it's the principal who signs off on it. So the DOE has to now has to look at this data that shows that, per population, again, Black students are overrepresented in every category, right? So in terms of superintendent suspensions and principal suspensions, they are something like 30% of the student population, but account for 50% of all suspensions. Students with disabilities, similarly, are only 12% of the student population, but account for 30% of all suspensions. And so when you have data like that has been gathered over the years, which advocates and attorneys have been doing in New York City, and you're in the position of sort of setting the tone of how discipline should be carried out in New York City public schools, there's a real opportunity there to say, hey, maybe this isn't working. Is it really true that kids with disabilities are the ones who are, purposely, that their actions are not in fact a manifestation of their disability, so we're going to suspend them because we think there's malicious intent behind their actions. So I think what I keep trying to get at is this: in order to balance the rights of the student in the class to learn and the teacher's ability to teach in a climate that allows for students who are acting out to be corrected, to be worked with, you need to change the policies, right? So you need to change the expectation that every offense is going to be treated in an extreme way. And there are the New York Civil Liberties Union put out a report in 2009 called Safety with Dignity that profiled several schools that do an excellent job of working with young people who are acting out, which is usually sort of a cry for help, a pay attention to me, and presents an opportunity to ask that student, what is going on in your life or in your day that's making you act out like this, right? And so then instead of taking the student out of the educational environment, out of the supports of a guidance counselor and perhaps other teachers and peers who can help him work through his issues, instead of doing that, you keep him connected to the school community, you keep him accessing education. And it's those school climate strategies that I think help sort of answer that question.
So I guess maybe this is something that you wrote about that I think you called or positive discipline or restorative justice. Is
Sure,
that the idea?
Sure.
And then I guess if you could touch on that, but then also I think you've written about sort of the training that's necessary to implement those ideas.
Yes. So I think I'll talk more broadly about the positive behavior intervention and supports models. So the most successful models are school-wide models where right on, from the top down, the principal, AP, deans, and teachers and students all buy into this sort of corrective and communal justice approach. I am no expert in training or in delivering those models, but what I do know is that in the schools where the first response isn't to kick the child out of school, but is instead to sort of assess what is happening. Students feel safer in school. The graduation rates are higher, and achievement levels are higher overall. So I think that if you have an opportunity for a school-wide approach, that's best.
Now, I guess since this is a discussion on the DOE and schools in general, it wouldn't be any fun if I didn't ask you to grade something. So
okay.
I'd like you to grade the fairness and consistency of the Code of Conduct's administration in the New York City Department of Education.
Wow. So I would have to grade schools in order to do that, because honestly, so we have worked with the Department of Education for a few years now to get them to reduce the number of suspendable offenses that they have in their discipline code. And to be quite honest, they finally listened to us, and we were finally able to work together. So we give them a positive mark for effort. So that's been helpful. I think, though, the challenge again lies in retraining principals who are used to this sort of knee-jerk zero-tolerance approach to consider some of the alternatives that they've put in the discipline code. So, for example, one of the really wonderful things that the DOE did was they inserted options for guidance interventions. So prior to the 2012-2013 year, you had an infraction on one side and possible consequences on the other. And for some infractions, there was a range of consequences, and then for others, there was a zero tolerance response, such as an immediate suspension. So in this current school year, 2012-2013, the DOE added a middle column, which sort of listed, consider sending the student to a guidance counselor. Consider talking to the student about what happened. Here are some de-escalation strategies. The DOE also helpfully included descriptions of some of the positive behavior interventions that we just talked about, such as restorative circles, restorative justice, and there's another one about community sort of problem solving, know, and all of those, and the schools that do practice this work have seen really wonderful results. And so I think that we are inching in the towards the right direction with the changes that have been made to the discipline code, but we're certainly not quite there yet.
Now, do you think that students, since at the heart of it, your work is really about students' rights, do you think that students are adequately informed about the Code of Conduct? I mean, do they have a sense of how their conduct is going to be going to impact their life, or how their conduct is going to be taken care of by the school?
Yeah, I would say in general, for the clients that I have had, the answer is no. And I think it's in part because even though, I just had a case where, for example, in the discipline code, you cannot suspend a student if they bring a cell phone or have their cell phone out in class. You can't suspend them for that, right? But what you can suspend a student for up to 5 days is defying the authority of a principal or a dean or a teacher. And so even though the student may have thought, well, I'll be removed from this class for checking a text message, or, even if they knew that this existed in the discipline code, they could actually wind up getting suspended for something else because the language in some of these infractions is so broad and can capture some of that, sort of typical teenage defiant behavior. So I would say there is no, students don't have the expectation that any number of penalties could probably be thrown in their direction.
Are they taught about the code, or are they given a copy of the code? Is this something
I
that
think,
they have to interpret themselves? Or
yeah, so that's a great question, and they're not taught. I think, again, it goes back to the school. I would hate to say, that there is no school in New York City that does this. Some schools do a really great job. And, again, some of those are profiled in the Safety with Dignity report that I mentioned. But I'd say for the vast majority of the time, students really are not taught. And the DOE doesn't do much to require principals even to instruct their teachers and students in what has changed in the code from year to year.
And beyond implementing some of these reforms that you're talking about that seem to be progressing into the system, moving away from zero tolerance, could there or should there be any effort to sort of work with the kids that were adversely impacted by very hard zero tolerance policies whose permanent records are damaged, so to speak? Right,
absolutely. I think that goes to the heart of the work that we do as attorneys, right, which is to be the best advocate that you can be for your client. And so I think that the best approach, to reforming the system is one that has many prongs, one in which where you're working with your clients to protect their rights, and also to connect them with resources, right? So as you just said, and as I think we talked about earlier, if a student misses so much time from school, they get the feeling eventually that if a principal is sick of the child speaking up in class and doesn't sort of ask what's happening, and then he just keeps getting suspended for 5 days at a time, 5 days at a time, 5 days at a time, eventually the student's going to think, well, the school doesn't want me here, I may as well stay at home. And or the student will act out in other ways, which could lead to an arrest, and that then sort of leads the child down that path to the school to prison pipeline. So I think that there needs to be a lot more in terms of reentry when a student that has been suspended is coming back into the school system. I think just an interesting statistic is there are over 5,000 police personnel or school safety agents in our schools, but only 3,000 guidance counselors. And I think that sort of shows what the priorities are, right? So if we're talking about efforts to work with young people who have been harmed by this strict disciplinary system, one of the things, and one of perhaps the easier things that we can try to change would be to build back in some of that actual guidance so that students can learn from their mistakes versus arresting them.
And how should the New York City school system deal with bullying, in your opinion?
Oh, that's a great question. And bullying is so difficult. I would say that a lot of the suspension cases that we take, unfortunately, have a bullying component to it. So first of all, what New York City has is a Dignity for All Students Act. Actually, New York State has a Dignity for All Students Act, which is basically an anti-harassment, anti-bullying law, which requires schools to develop a more positive and nurturing environment and to sort of pay attention to when young people are being bullied in terms of bias-based bullying and things like that. So race or gender, identity, religion, all of that stuff is protected under DASA. In New York City, we have something that's called the Respect for All program. And I believe at this point, and folks in my office would actually know a little bit more about this, that it's going to be sort of replaced with the Dignity for All Students Act citywide program, where there is a process for parents to complain if their child has been bullied. But honestly, what the city can do to deal with that is to make it easier, right, to make young people feel safer in their schools. One way they can do that is professional development, right? So to train teachers to sort of pick up on what is bullying versus what is drama. You can train administrators in different ways to respond to that. So, for example, one thing that we hear about a lot that schools do is they try to do peer mediation between the bully and the bullied. That never works, right? Because the power dynamic is such that the bully already has the power, and if you're forcing these two students into this space, you're only going to reinforce the fear that the bullied student feels. And so I think that like some research perhaps might need to be done, and some instruction from the top down might need to be given out, in terms of how to work with young people, how to address this issue school-wide, but also how to train young people to be respectful. And again, I think you're avoiding that problem, and it's really just a Band-Aid if you're just going to keep both kids out of the school without addressing the issue at all.
Well, I mean, this is really a fascinating subject, and it's unfortunate I didn't get a chance to go into public displays of affection, or I wanted to go deeper into due process, but we are running out of time, so hopefully we'll be able to do this again.
Absolutely.
Thank you for joining us on Media Reporter, and please tune in for the next episode. So
Yeah. Okay.